Okay, so I'm going to start the seminar. My name's Jose Alvarez. Welcome to the U.S. Asia Speaker Series, the U.S. Asia Law Institute Speaker Series. We're really excited to have perhaps the leading trade expert in the United States, an expert on world trading system to address the U.S. in the world trading system, the tariffs and WTO reform. You have his bio and a little bit about the book, but let me just say a few words for those of you who haven't closely examined it. Alan Wolff is a senior fellow at the Peterson Institute for International Economics. He's formerly Deputy Director General of the World Trade Organization, has long been engaged on this topic. He's oversaw at the WTO key divisions, founded the Trade for Peace Initiative. He's had senior administrations, including as Deputy Special Representative for Trade Negotiations and General Counsel at the Office of U.S. Trade Representative. His book from Cambridge University Press, 2023, was actually considered one of the best books by Financial Times of 2023 in economics. The world trading system. I have read it, and you've missed something if you haven't read it. If you think WTO is a dull technical subject, you'll have something else coming to you if you actually sit down and read this. It's a book about the values of the WTO, about leadership, not just in trade, but generally about how to be a good negotiator, and had a detailed forming the organization and especially its system of dispute settlement. He has a great deal to say, so we've decided that in this format, he will have 20 minutes to collapse what is an enormous book, but also addressing more contemporary issues since its publication, and then we'll open it up for Q&A, both from me, from the live audience, and any we get online. Those who are joining us online, you can put your comment. Be looking at that at the end. So over to you, Mr. Wolff. Say what you want about the book. It's all yours.
Thank you very much. It's a pleasure to be with you and to be working again with NYU, which I, over the years, worked with NYU law professors on various projects over time, including most recently filing an amicus brief in the tariff case before the Supreme Court with Rod Hills, and with Carla Hills. Rod Hills and I co-wrote it, and Carla Hills and I co-signed it. And let me start with the tariffs only because it dominates our thinking. It used up a great deal of anyone who's involved in trade, world trade, no matter where you are. You spent probably a lot of your time, if you were a trade policy official, dealing with Mr. Trump's tariffs over the last year. And now you're dealing with the aftermath, namely, what's the next onslaught of tariffs? The president has said, as has Scott Bessent and the Treasury Secretary and Jameson Greer, the U.S. Trade Representative, that they're intent upon replacing the International Emergency Economic Powers Act tariffs, the IEEPA tariffs that was struck down by the Supreme Court, with equivalent tariffs under authority, they say, of Section 301 of the Trade Act of 1974, and that's retaliatory authority, and Section 232 of the Trade Expansion Act of 1962, namely the national security provisions. And of course, under the first Trump administration, we had and still have, through the Biden administration into this administration, the 232 tariffs on steel and aluminum, and to which others have been added and will be added. So the first threshold question is, do the deals hold? The EU has said, the European Union has said, we want to keep our deal, so don't put other tariffs on our goods. And it's really ironic and maybe bizarre that a deal that many in Europe said they were coerced into signing because of Trump's tariffs, the initial tariffs on April 2nd, the reciprocal tariffs of almost a year ago, that they were coerced into a deal, and they say they want to keep it because at least there was a degree of certainty. A 15% tariff and some other provisions were in the deal, but they knew where they stood. The markets, after reacting very negatively in April of last year, sort of settled into the Trump use of tariffs, and the Supreme Court said, well, actually, the Congress has the tariff power in this set up under our Constitution, and not the president. So Article 1, not Article 2 of the Constitution. And by the way, IEPA, the emergency 1977 emergency statute, doesn't mention tariffs and doesn't have tariff authority in it. They could have gone another way. They could have said, well, you could use tariffs as a sanction, or say against India if it bought oil from Russia. It might have been an ancillary authority, but say no. They didn't get into that. That wasn't before them. The facts before them were the reciprocal tariffs, and the Supreme Court said 6-3, no. And the clearest voice on the court was Justice Gorsuch, who said the president doesn't have tariff authority of his own; it has to be delegated, and you can't delegate it this much of it. And if you're the Congress, complete loss for the administration. And rumor is that there may be a blanket 301 series of tariffs. 301 retaliatory tariffs can be based upon that which is unreasonable, which is a very loose standard. What is unreasonable? It's in the eyes of the beholder, and the beholder is actually the president or the U.S. Trade Representative. Or unjustifiable, meaning in violation of trade agreements, which would be sort of an oddity, since the U.S. is in complete violation of its own trade commitments, and a burden on U.S. commerce. Well, that is a very flexible standard, and bound to be tested at some point. So will there be blanket tariffs under 301? It wasn't designed for that, but it doesn't say it was not designed for it. And so far it's a blanket tariff against China has been in place now since the first Trump administration and through the Biden administration. So if you're an Asian country, in particular, take Japan and Korea, and you're heavily dependent on the United States for defense under the nuclear umbrella, potentially, of the United States, then you think twice before saying to Mr. Trump, you remember that deal we had? Well, we're walking away from it. It's, I think, unlikely that they will, but they'll watch to see what others do. The EU Parliament has said, let's find out what's going on before we approve the deal that we had. So the situation's in flux, and we have 150 days under the Section 122 of the Trade Act of 1974, the Balance of Payments Authority, for the administration to figure out what it's going to do and do it, and others to react. It's not not a practical thing to do to sue the administration and get instant relief from Section 122, even if there were no balance of payments emergency, for a variety of reasons. One is it's a 150-day statute, at which time whatever was done expires. It doesn't say, we want to know from a series of respected economists whether there's a balance of payments crisis. It says a problem. It says the president will determine it. And so it's very difficult to get behind a presidential determination, not impossible, but just like into IEPA, I never thought that the court would say there's no emergency. They could have, but they didn't. They were leaving to the president the determination of emergency. So the bilaterals stay in place, I think, for the time being. It's a bit of a mess because Trump can't hold up his end of the bargain unless he uses 301 or 232, potentially one other statute that is mentioned from time to time, but not recently, is anti-discrimination statute in 1930, Section 338 of the Smoot-Hawley Tariff Act, Tariff Bill, the 1930 Tariff Act. Well, where does that leave us with WTO reform, which is the other half of this discussion this afternoon? Both the U.S. and the EU have tabled interesting papers on reform. One thing to be said about the U.S. participation at the WTO currently is it hasn't left. It pulled out of some 60 international organizations, but not the WTO. It has a good, solid ambassador, Joseph Barloon, who presumably we don't know, but presumably wouldn't have taken the job or wouldn't have been offered the job had the president already decided to leave the WTO, which he threatened to do during his first term. And the U.S. allowed a respected individual from the Council on Economic Advisors, D.J. Nordquist, to be a U.S. deputy, U.S. origin deputy, a director general of the WTO. So there aren't, and plus, amazingly enough, the U.S. paid Joe Biden's back dues. The Biden administration somehow left town and failed to get the check cut to send to the WTO for the 11% of the dues of the organization that it owed. It is rather amazing and sort of low profile that here's President Trump paying Joe Biden's bill to the WTO, which is interesting. Now, that said, the paper that the U.S. tabled on WTO reform says no MFN. That era is over. The era of MFN, most favored nation treatment, that has been around since before there was a country of the United States. The first MFN agreement, the first treaty that the United States entered into was during the period before George Washington took office. So it was in 1778, a trade agreement with France that the United States had most favored nation. It was conditional MFN, but MFN. And the U.S. has always had MFN. In the earlier part of the 20th century, it became unconditional MFN instead of conditional MFN. So the WTO is based upon, as is the GATT, unconditional MFN. And I think that I don't have a substitute. Maybe someone online here or in the room has a substitute for MFN. I don't know what it is as a system. power politics. That's the system that's the opposite of MFN. You get whatever you can negotiate with somebody else. But the U.S. proposal was in favor of having plurilateral agreements, which the GATT era did have, in favor of transparency. I mean, these are all good things. There are some things dealing with state-owned enterprises. Now, some other things in there are a little bit harder for others to swallow, like the non-reviewability of national security determinations, and a series of things that the U.S. paper says the WTO just ought not to get into, which others may want to get into. The EU tabled its paper, and it said, this is further explained by Maros Sefcovic, the EU trade minister, commission trade minister, said we should revisit MFN. Don't know what he has in mind, but presumably he would like to cure imbalances. Well, what imbalances out there? Might be looking at China. China is a very tough customer to rebalance with. So an interesting question. But it calls for a steering committee. The WTO tries to organize its work not only in committees, but for decisions in a committee of the whole. 166 members sitting in a large council room trying to make a decision. And it's not a way to run anything unless you're a Swiss canton, of which there was one, in which the way they governed, this is until 10 or 20 years ago, was to file into the central square of the canton, and that's how they voted. Well, you can't really run a world trading system on that basis, so something had to be done, and the EU is thinking about it and saying we ought to. And they both agree that special and differential treatment for developing countries should be an as-needed basis, so tailored to the needs of each individual developing country. They also have, the EU has an idea that it wants to review the level playing field, which presumably would mean that U.S. industrial policy, which has come along, and others like China, have to be regulated in some way. What happens in Yaoundé, Cameroon, end of March? Potentially, at most. Something is done to, if the Indians get out of the way, allow the investment facilitation for development agreement to be made an official part of the WTO acquis, the agreements of the WTO, but that's subject to no veto from the likes of India, perhaps not also from South Africa. Moratorium on customs duties on e-commerce, which is called, actually in those days, electronic transmissions, extended potentially. And the beginning of a work program on WTO reform issues. That's not huge, it's not too ambitious, and it may not be reached. So I was invited to go to Cameroon, and I'd like to see Cameroon. I've not been there, been to many other places in Africa, but not to Yaoundé. But I'm not going. I went to Abu Dhabi, came back very enthusiastic about what had been achieved, but it was just a simple extension of the customs moratorium. So I attribute that to jet lag and not anything more profound. That's about 20 minutes into our time. You have a series of questions you shared with me, but we can take them from individuals or from yourself as you see fit.
So let's just start with some of the things that you've already mentioned. It is surprising, given the U.S. withdrawal from a good chunk of the UN and a consistent lack of payment of its dues, that the situation is quite different with the WTO. And even given the skepticism you've expressed with the reform agenda released by serious enough to have a reform agenda. And I guess one question for you that may be obvious is why the same president who's doing unilateral tariffs is still engaged as much in the WTO. What explains this exception to considering a multilateral organization as still serious enough?
Yeah, were we privy to a discussion in the White House, if there is one, with the president on this subject? One could say, Mr. President, do you understand that we're not bound, but everybody else is? And that's not a bad situation to be in, that they can't retaliate without violating their own obligations. They cannot, they have to obey sanitary and phytosanitary restrictions, which our farmers care a lot about. They have to, and this is something one would never say to a president, they have to live up to the customs valuation agreement. Simply, that's in the weeds for a president. But basically, they're bound and we're not. And we care, our farmers care a lot about the agriculture agreement. And we care about transparency. We want to know what those other folks are up to. We are very transparent because on X, or what used to be called Twitter, at 2 a.m., we'll announce in this country that the tariff went from 10 to 15% on under Section 122. What other country announces everything out in the open pretty much all of the time? So we need the transparency that's offered with respect to what others are doing. Anyway, there are a dozen reasons why the WTO is pretty good for the United States and not onerous in the fact that the U.S. just ignores what it finds inconvenient, particularly MFN and bound tariffs, and thirdly, of course, dispute settlement. So, Mr. President, we're not bound and others are. Why don't we keep that? Quite possibly that. Now, does that take place? That conversation take place, or actually, Mr. Trump's busy doing other things and hasn't gotten around to saying, I don't like anything international, and I certainly don't like the WTO.
Right. So another thing you addressed, but briefly, are the existing trade deals. And remind you that this is the U.S.-Asia, so we're focused on the Asian trading partners. And some people would say that they've been the most proactive and responsive since Tariffs Liberation Day. And there's lots of negotiations, some still going. Months, we've had as many as 10 Asian countries reach agreements to reduce their exposure to what they thought was AIPA. And now they've got, as you say, considerable uncertainty. But I guess your book is written, as you indicate, as partly advice to people. So if you put on your advice hat, what exactly would you say to South?
I would say particularly Korea and Japan, but perhaps also Indonesia and some others. And Thailand, you cut deals. Do you, if you feel that you're free now to tell Mr. Trump that you're not going through with the deal, feel free to just go over to the White House and tell him. And that would be a big mistake. You can worry about it. You can think about it. You can see what you want to do about it. But first of all, the president has rather massive authority under 301 and 232 on subjects of interest to you, your country. So, this scorpion has not been totally, its stinger has not been taken away. So tread carefully. Plus, with respect to Korea, are you going to tell the president that you're not going to help build, transfer technology and build ships? And he's over there he has troops over there in Iran. Our Navy is getting antiquated, needs refurbishing. You leave this deal at your own peril, but you figure out what you have to do and what you want to do. So I'd tread very cautiously at this point, and I think they are. I mean, you haven't seen no announcement that they are moving away from the deals they cut. And before we finish, we ought to talk about what they could do at the WTO in a positive sense and what their role can be.
Right. That was where I was going to go next. Your book has got quite a bit of prescriptions along those lines. I'm curious what you would say on that front to those particular countries or others in Asia about how they should approach those kinds of reforms.
Well, what's interesting to me is that when you look into it, the Korea, Japan, Singapore have been in the lead on much of what's been done at the WTO in the last 30 years. The trade facilitation agreement was something that the Singapore, but also Japan and Korea were very active on the information technology agreement. Korea was in the lead. Singapore was there. Taiwan, Malaysia played key roles. They are very proactive on the Japan, of course, is a co-convener with New Zealand, with Australia and Singapore of the work that's been done on the digital economy, e-commerce, joint statement initiative. So these are countries that are very proactive. I'd say there's a dual track. There's what can you do on a global basis or try to do on a global basis, and what will be done regionally. TPP became a Japan project when the U.S. dropped out, and they succeeded in driving it through to conclusion. Korea ought to be in there, and hopefully will. So I think there'll be more regional progress. Digital economy agreement will be expanded, I think, and the Asians will be in the lead. It was with Prime Minister Abe that they got very interested in leading on e-commerce, they being the Japanese. But Korea's in there as well. I think they're well positioned. The next major subject is what's the effect of AI on the world trading system, and what's to be done about it. There are, of course, big pluses for the world economy, and there are also real concerns. And Korea and Japan are well positioned to take the lead on looking at what should be done on a global level and what should be done on a regional level with respect to AI. My book doesn't go into AI because it just wasn't a subject at the time. in 2023, but it is now. And the U.S. is not going to take the lead on that. The EU will probably be pretty cautious, and I suspect China will too. In reform, in the agreements to date in the WTO and in reform, the middle countries have been more active. Canada will be. It wasn't for a while, but it will be again. But it's the Asians will be particularly active, I think, and in a leadership role.
So you mentioned Canada briefly, and I think recently in one of your postings, you talked about Mark Carney's vision for action by middle-sized economies. And you said this wasn't just stirring rhetoric, but a viable possible strategy that could be embraced not just middle countries, but smaller economies as well. So can you say how that strategy could, if adopted, affect approach to WTO reform? You mentioned the dual is that dual track mean that, for example, even though your book extols multilateral regulation, you say not so much about the comprehensive and progressive Trans-Pacific Partnership, the CPTPP. You just mentioned it, and it sounds like you're pretty positive about it. Mark Carney vision, or is it something that you would encourage the Trump people to revisit? That instead of ripping it up as the first thing he did in Trump 1, Trump 2 should actually join the TPP?
Yeah, of course, I think they ought to. I don't think they will, but their point of departure is a little bit different than mine. I view the free trade agreements like a TPP and the some of the others, DEPA, the Digital Economic Partnership Agreement, as laboratories for what can be done ultimately on a multilateral basis. Because among 166 countries, it is, I should say members, economies, the likelihood of moving with alacrity is about zero. There's just no possibility. You cannot move that many countries with vast first, not only differences in interest, but differences in capability, capacity. If I were representing Mali or Chad or Benin or Burkina Faso, I'd say, I'm here because I want to see what you all can do to help me get more value added from my cotton production. So I'm really not interested in AI. It may help me, but I'm not going to take a lead in that. The countries with the capacity and interest to take the lead are really principally Korea and Japan and potentially Singapore. And the history of the last decade or two have been that the big countries, meaning China, the United States, and counting for a moment the EU in that list, have come in later. They've not taken the lead. I think that will change a bit with the EU. I hope so. But right now, those who can move most swiftly are the Asians. And, as I say, with respect to the negotiation of the digital economy, e-commerce joint statement initiative, it was Japan and Australia who, for Asia, really took the lead.
So we haven't said much about China and the ongoing negotiations between the U.S. and China. Now, I gather that U.S. duties on China have principally been under Sections 301, 232, countervailing duties derived from Commerce Department investigations. If those are the backbones, you could argue that the Supreme Court's decision doesn't have that much of a fundamental effect on the ongoing China negotiations. But I wonder if you agree, or do you think it has shifted a bit the leverage to China on those negotiations?
Well, a lot depends upon, maybe it shouldn't, but it will, on the personal chemistry between the president and the two presidents, Trump and Xi Jinping. Xi Jinping, knows what he, I think, needs to have with respect to freedom to pursue industrial policy with state ownership to the extent he wants it, which is not something that's really regulated by the WTO at all. The Section 122 was a surcharge, so it's layered on top of existing tariffs, but it is temporary, and China has turned out to be a rather patient place in terms of, in most respects, not all, not in terms of trade coercion, but in terms of biding their time and seeing what will happen next. It is conceivable that the two countries will have a trade agreement, and that will limit a lot of the exposure to future trade actions by the United States. If matters such as soybean purchases go through and are increased. I understand that soybeans are bought mainly on the spot market, not contractually committed to, say, Brazil. If that is true, then instead of U.S. agriculture seeing an eroding market share in China, that could be reversed. And there's a lot of mutual benefit that can come from discussions, including continuation of rare earths access by the United States. So the U.S. has some things that it wants from China. China wants to be held harmless from a constant threat of trade actions. So there's a making of a deal if they wish it, and that is unpredictable. Maybe I should be able to predict it, but anybody who can say exactly where Mr. Trump will be on this subject is better informed than I am.
Oh, great. So one of the things that I admire about your book is how candid you are about some of the mistakes that occurred under the WTO. And you focus a great deal on your desire to have and continue to have enforceable trade dispute settlement scheme. But I guess I would love to read your book about what you thought went wrong with the appellate body in particular. I gather you thought that it had a priority that was probably wrong to clarify and harmonize WTO obligations instead of relying on just settling each dispute one case at a time, good mediation. And I think that could be a diplomatic way of saying that the appellate body was too judicially activist, or maybe it was that the states expected them to be by bringing some disputes. But it also it reminds me that you're talking in a law school where many of us, I suspect, were not, but were consumed by the WTO case law precedents. And maybe we're all partly to blame for over-legalizing trade dispute settlement. And I guess I want to invite you to say, were we, in short, the lawyers, to blame for the appellate body's demise?
There's something to that. It's not, the blame. There's not blame to go around. The Any NYU graduate would have written a more succinct and readable opinion than many of the decisions of the appellate body. They did not have the training that NYU or an American law school provides, or any other law school for that matter, in some cases. So I think the clarity they had of why they were there was not what it should have been. Now, they were under pressure as well. Countries like to throw everything they could. Maybe lawyers do this in the U.S. too, of course, but throw every argument they could and see what would stick. And then the countries would say, this is a diplomatic setting in Geneva, countries would say, you didn't answer all of the points I made, even if they're totally irrelevant. So they were under pressure to take up and mull over for diplomatic reasons, I think. This is according to appellate body members and staff. They were under some degree of pressure to answer everything that was out there, but then they'd go on and answer things that they thought of themselves, not having this focus on case or controversy that we do in our system. So that was one issue. Another issue is there is no legislature in the WTO, which would be members setting new rules. So there was a lot of pressure to, if you want to get a rule change, say for anti-dumping, then you try your luck at the appellate body, because they're pretty good at, you could say, interpreting, but you could also say writing new rules. They interpreted their way out of the safeguards agreement. They interpreted their way out of parts of anti-dumping. They interpreted their way out of where state-owned enterprises were involved. Finding a subsidy in a non-market situation. And from a U.S. point of view, the U.S. said two things, really. One is you have, whether this is true or not, but the U.S. certainly thought it, you are making law, not interpreting law, and there is no effective oversight of what you're doing, because the dispute settlement body rules by negative consensus, which is a curious concept of, if all agree, including the winning party, to do away with a decision that just won, then it can change the outcome of a dispute, but otherwise it can't. So the DSB, the dispute settlement body, became a nullity. It became an employment agency for the appellate body and nothing else. Pretty much nothing else. Others may have a different view of it. The system ultimately broke down. It was not providing timely responses. It blew past all possible deadlines. It sat on cases after its members were no longer, their terms had expired, which they really needed permission to do, but didn't get it. It didn't ask for it. So there was a lot wrong with the imbalance in the system, and largely due to the fact that there was no legislative possibility, no negotiating possibility. And I think that, and I've written on this, I think that what ought to be taking place now is, I favor binding dispute settlement. I don't favor reappointing members of the appellate body, although I tried to get that done when I was at the WTO. Um, the substitute, the interim arrangement, the MPIA, multi-party interim arrangement for dispute settlement, a substitute appellate body, has only had 2 cases that it's gone through in 6 years. Why is it that the MPIA, which has appointed very good people to it, Alejandro Jara of Chile and Just Poland, European, and a number of others, have written some very good decisions, but only 2 of them. So why is it that it was always nearly automatic to appeal everything at the WTO to the appellate body, and when you have a substitute appellate body that has no precedential effect, you don't have a flood of appeals? Were countries gaming the system? And partially, of course, they were, because if you appeal, you don't have to suffer the consequences of an adverse panel decision. And if the United States and you destroy the appellate body, you never have to live up to your obligations at all if there's a case against you. When I was acting Director General during an interregnum between Azevedo leaving and Ngozi Okonjo-Iweala coming on board, for those 6 months, I tried to get my colleagues to agree, the other deputy director generals, not to accept appeals to the appellate body because there was no appellate body, but I was unsuccessful in that. So I do favor binding dispute settlement. It'll be very, very difficult to get back there. The U.S., maybe some of you know good examples of many places where the United States has accepted binding dispute settlement. The WTO stood out as really the prime example while it existed.
Great. So now we'll turn to the audience, and I guess we'll start with the ones here live. You get the privilege of asking the online. So anyone here want to ask a question? Now's your chance. If you want to say who you are, that'd be great.
Yeah.
Yeah. That's right. Okay. Hi, Mr. Wolff. Thank you so much for your remarks. My name is Travis Bahis. I teach international trade at Brooklyn Law School. Suggestion that it'd be better for the credibility of the United States and of the WTO and perhaps international law generally for the U.S. and the WTO to part ways, because we're formally bound by these rules that we, quite flagrantly have disregarded, and openly so. And there doesn't seem any sort of hope of coming back into at least substantive compliance with the rules. And so I'm just wondering if you that.
Yeah, other members actually aren't asking for expulsion of the United States, and hope for a time when this is all treated as an aberration, and the U.S. Manages to live up to its obligations, and they don't see advantage in the U.S., which does not violate all of the agreements of the WTO. It violates its 2 principal obligations of MFN and tariff bindings, but they don't see a plus of just getting rid of the WTO, getting rid of the United States out of the WTO. Now that could change if the U.S. becomes pretty much the India of the WTO, namely trying to block everything in every direction. That view may change, but it isn't the view now.
We have one question from online, which is what respect to the WTO system reforms if a Democrat were to become president. The suggestion is that there's a bipartisan consensus that the WTO was not working. So there's some skepticism as whether it would make any difference. What do you have to say on that?
Yeah, I think presidential leadership, and this is not by partisan party, but by the nature of the person who comes in, um, makes an enormous difference. In 1970, the Congress enacted a trade bill that had quotas on textiles and footwear and a trigger mechanism to put quotas on everything else. The Mills bill, it was horribly protectionist. Would have made Smoot-Hawley probably look like a relatively liberal enactment compared with that bill in 1970. Didn't pass. It and some very wise leadership in the Congress made sure that it was had so much in it. It was combined with Social Security reform and health reform, that Medicare reform, that it died. 3 years later, along comes Richard Nixon, and he says, I want you to give me authority to change any law in the United States subject to a I've forgotten what, I always forget whether it was a one house or a two house override. But if I say it's needed to, that changing that law is needed to um, uh, implement a trade agreement. And the House said, okay, gave him a two house override, I think. And the Senate said, no way. But what we'll give you is an up or down vote and within a reasonable period of time with no amendments. And that was Fast Track or Trade Promotion Authority, which expired, I think, foolishly, allowed to expire by Joe Biden, who had no use for trade agreements and no use for dealing with the Congress on them. Somewhat Trumpian in that respect. So a lot depends on presidential leadership, and both Republicans and Democrats have led in a direction of more open engagement with others. And it'll be hard to get back there, but not impossible. Democrats are saying they want smart tariffs. Not clear which those are that are smart. But that's something that's being said, but we don't know who the candidate will be and what he or she will want to do with trade. Elections are usually not run on trade, although the last one was with Trump said he had two objectives, really, two principal objectives. One is seal the border, take care of illegal immigration, and the other was he liked tariffs, and he said, I'm going to have a 10 or 20% general tariff and a much higher tariff on China, and he campaigned on it, and the Americans voted. So he would say, I have a mandate for the tariffs I put into effect. Well, the next president's going to have a mandate too, and it's not going to be the same one for high tariffs, because the American people, generally speaking, loathe the tariffs that have been imposed.
So we have a question from online, which goes, which adaptation strategies, coalitions, plurilateral initiatives, procedural workarounds have you found most effective at preserving the functionality of, or have actually done something worse? I would also add, I suppose, the consensus rule. Is that something that was a good thing or a bad thing overall?
Well, correctly used, it was fine for a long time, and incorrectly used as a taking hostage somebody else's agreement so that you can apparently try to get something you want, in the case of India, although it's not even clear that that would be sufficient to get Indian acquiescence. So one thing I thought was the right solution, but I question that now, is that the just go ahead and meet just go ahead and do it. In other words, there's an investment facilitation for development agreement, all completely drafted, and the Indians say, no, you can't, we can't adopt that. Well, my way of looking at it is just say, well, we're meeting on Tuesday afternoons in room D at the Center William Rapin in Geneva. And the Indians can say, well, you can't do that. Say, well, we're doing it, which is what the JSIs, the Joint Statement Initiatives, did. Just do it. That's a workaround. There's a danger in that there may be something that I wouldn't like that actually adversely affects my interest if I were representing the United States or any other country. And you're going to go ahead and do that as well. Well, I don't like that. I like to have some sort of say in it. Voting is not acceptable because you could easily say, well, you have a faction that can attract enough votes, they'll put through anything they want, and they might want to bind me by it, and I wouldn't accept that. So there's no easy solution. Except for Singapore has said their consensus ought to be reasonable, and sure it ought to be, but it isn't being used that way. So I'd force the issue first of all with something that is already negotiated by simply saying we're going ahead with it, and it is going to be treated as if it's part of the WTO set of agreements. It will even print it in the same book as the WTO agreements. And you can be as upset as you want to be, India, about it. We're going ahead. And India will say, well, I'd rather have a system where consensus is reasonably achievable and not withheld unreasonably.
So we're getting very close to the end, but you mentioned administration's reform proposal suggesting that anything that involves a essential security or national security exception should simply not be reviewed. And I think you've written about the national security exception under Article 21, which is very important to many countries, including in Asia. And of course, you're aware that the Russia-Ukraine, that it has to be subject to at least good faith analysis. Do you disagree with that? What would you do with the exception of essential security or national security?
First of all, I thought the Russia-Ukraine decision was absolutely nuts. In other words, if you say, I've decided to lean on my next door neighbor by putting on trade restrictions, and I'll call them national security restrictions, and the panel would have gone the other way. If you say, but wait a minute, we have a shooting war. In fact, we're bombing the living daylights out of Kyiv every single day. So now can I also make sure that they can't ship us any food? And the panel says, oh, yes, that works. You have a shooting war, you can do it. That seems to me to be absolutely insane. Now, what we don't want to see, I don't want to see, is Section 232 becomes, as the United States has used it, not a matter of national security, but a matter of potentially, you could argue this one through case by case, but a substitute for the safeguard article of the WTO, that it's just giving protection. So if you want to just give protection, then thank you very much. Use the safeguard provisions, which should be workable instead of not being workable. It's not national security. Years and years ago, the Swedes, when they had an independent trade policy of their own, put national security restrictions on boots because an army can only march on boots, so they needed to make boots at home in Sweden for their soldiers. And they gave that up because of derisive laughter from the rest of the contracting parties. The WTO GATT said, "You're nuts," and so they withdrew the measure. Is there a way to have an administrable, sensible national security provision? And what we proposed in a paper that I co-wrote with a former general counsel of the Office of Special Trade Representative, Warren Moriyama, is you can use a national security excuse for a measure, and you just have to pay a price. Others can compensate themselves if they feel you didn't have a justifiable reason for imposing national security restrictions. So what you really did was you transformed just a protectionist measure into a national security case, and it isn't one. So, are there ways of negotiating something sensible? I think so. Hasn't been tried.
Thanks so much. So we have reached the end. It ends at 6, but there is one questioner that we should hear from. I told you he'd be here from the ministry, so please go ahead. We'll excuse this one case.
Very much for giving me the floor. And first of all, thank you very much, Professor Alvarez, for hosting this event. And then I would like to say thank you also to Mr. Wolff for joining us today. Your presentation was quite insightful, and we learned a lot from your presentation today. My name is Hiroyuki Mase. I'm from Consulate General of Japan in New York. And before coming here, I previously served as a director for the Ministry of Foreign Affairs of Japan. I would like to simply say that I echo many of the points that Mr. Wolff and Professor Alvarez raised during today's seminar. And one thing that I would like to touch upon is the problem of a lack of legislature and then imbalance. Obviously, WTO reform is very important, and then one of the important components is how to modernize the dispute settlement mechanism. But at the same time, it should go with how we can make a decision and how we can conduct effective rule making. That's also our viewpoints here. And from that perspective, naturally, the efforts, as you mentioned, like the incorporation of development agreement into WTO laws is of critical importance. And then e-commerce, digital economy, as you highlighted a couple of times during the Mr. Wolff's presentation, is also something that Japan, together with other like-minded countries, are promoting. And then, obviously, other areas like decision S and DT, and then level playing field, something that we have in mind as a potential areas to achieve in terms of WTO reform in view of the upcoming MC14 to be held in Cameroon quite soon. Last point I would like to make is on a regional front. During this seminar, regional efforts and framework such as the TPP. I would like just to mention that Japan played a critical role in saving TPP and then having a CPTPP. And we value CPTPP not only as a trade agreement, but also a forum to discuss the various issues of common interest among partners. And we would like to advance in that way in the future. Thank you very much.
Don't know if you want to respond to any of that, Mr. Wolff. I think he's agreeing with you.
Just a quick response. One point is that the professional bureaucracy in the Geheimnishow, in the Foreign Office and Foreign Ministry, and MITI in particular, but also of course, the Finance Ministry, are some of the best civil servants in the world in terms of training and capability. So I look forward to Japan continuing a leadership role in the WTO and in what I hope to be a closer relationship between the EU and the CPTPP. And I hope that moves forward. I don't know whether it becomes an FTA. That takes time and effort. But a real coordination that becomes very beneficial is not only on a regional basis for those involved, but as a laboratory for what can be done on a multilateral basis. So I wish you and your colleagues well at the ministry, and hope to see. I'm very short of patience for some real progress to be made. So I'm impatient. I hope that progress will be made soon of a concrete sort on coordination of policy on that axis between the EU and CPTPP, with others later on joining in who are like-minded. So I thank you very much for your comment.
And thank you, Mr. Wolff, for participating. Hope to see you sometime back in our series. Thanks again. Bye-bye.
Welcome. Good to be with you. Take care.